Tonight's topic is on removing friction from the estate planning process using cloud technologies. This is a presentation of the FinTech Realtech Meetup. We're a special interest group of the Silicon Valley AAII, where we discuss current and emerging trends in finance and technologies and how consumers like yourself can benefit. We are a special interest group of the larger chapter, Silicon Valley chapter of AAII, which you can go for more information to find out about us at siliconvalleyaaii.com. So at siliconvalleyaaii.com or .org, I think both work. We have other main events. Our last main event was actually a couple weeks ago, and so there's no main event in December. And then, but there are still going, I think there's one last financial planning special interest group, and then also the investment discussion, and also the computerized investing, otherwise known as SIMI. So our special guest tonight is Chris Hall. He's the founder of EP Navigator, Estate Plan Navigator. The role or the mission is to provide access to quality legal assistance for the masses. The goal is to take advantage of today's powerful technology, pair that with the still very important human element, especially when it comes to estate planning, which can be a very permanent thing and needs to be done very carefully. Prior to that, Chris worked in the real estate industry and also as a financial advisor, which he exited, and then he spent 10 years trading futures and also managing a real estate partnership. He's a local, or was a local. He moved to, just like the many transplants now that are moving out of California, he's moved to Dunedin, Florida, which I think it's, Chris, is that like, that's on the
West Coast.
West Coast, okay, like it's south of Miami, right? Or is it north?
Well north of Miami and on the other side. Yep,
okay.
On the Gulf of Mexico.
Oh, okay, got it. Okay. Yeah. So, right, okay, yeah, Miami's on the east side. Yeah, so that's Chris, and I will just ask if you could mute your audio and then also turn off your camera just to save on the bandwidth. For questions, feel free to chat that over. You can even do it during Chris's presentation, just so that you don't forget. Just chat that over to me, and then we'll take Q&A at the end. So enjoy, and I want to welcome Chris. So Chris, go ahead and take it back, and
Will do.
Yeah.
Well, thanks for the intro, Roland. I appreciate it. I'm not sure I can keep up with your radio pipes, but I'm going to do my best. You've got an awesome radio voice. I'm sure you've heard that.
Thank
before. Well, we'll get going. Like Roland said, tonight we're talking about removing friction from estate planning using cloud tech. We are going to, oh, hang on, I've got something here. There we go. Our topics tonight, we're going to work through, we're going to start by talking about trends in estate planning, legal technology, excuse me, and how access to legal tech is changing. There's a lot happening right now. We'll get into that. We'll also talk about what I'm calling the friction. Really, that's just what it is that's keeping people from completing this relatively simple task. And that's interesting. There's a lot of reasons why people hesitate. Then we'll get into a little bit about living probate. It's a topic that I don't think many people discuss. It's really the proof out there that estate planning really isn't just about dying. Most people, you ask that question, that's what they're going to say. Hey, that's about getting your affairs in order when you die. So we'll get into that. And last, we'll talk about how my company, EP Navigator, is changing the landscape when it comes to estate planning and how it's delivered to people. So let's jump in. We're going to start first with the trends, as I mentioned. One thing that's happening right now that really is a big indicator is money. Money talks, right? So we're seeing in 2019, somewhere between $1.5 billion and $2 billion was invested into the legal technology space. So that's an indicator clearly that technology has entered the legal world. It's here to stay. One of the biggest things really that's pushing that is AI. AI is clearly going to play a big role in all types of legal assistance, not just estate planning. It's interesting in that one of the biggest firms in the United States, and of course, right in this very moment, the name is escaping me, but they recently leased somewhere in the neighborhood of 23,000 square feet and hired a bunch of attorneys and very smart tech people to just sit and not sit, but work on how they can approach and use the technology that's coming and how it's going to change the landscape. Interesting that a recent study that conducted by a legal AI platform called LawGeeks, they did this in together with law professors from Stanford, from Duke, and from USC. And what they did is they pitted 20 experienced lawyers against the AI. And that AI had been trained to evaluate legal contracts. And these attorney competitors were given 4 hours to review a non-disclosure agreement and identify 30 legal issues with that document, including arbitration, confidentiality of relationship, and indemnification issues. And they got scored by how accurately they could identify the issues within those documents. And unfortunately for humanity, they lost the competition. They got crushed. The human lawyers achieved on average an 85% accuracy rate, while AI achieved 95% accuracy. The AI was also able to complete the task in 26 seconds, as opposed to the human lawyer took 92 minutes on average. So clearly AI is entering the space. It's going to change everything, but it's really going to make a lawyer more efficient, in my opinion. It's going to allow the attorneys to possibly broaden their offerings and maybe focus more on service and how they can help people and let the technology work for them. Another big change we're seeing is, and I think this is could be in part or probably in part by many younger attorneys entering the field, but they're starting to embrace the change. Whereas just as recent as 4 or 5 years ago when I got involved with this, lawyers didn't really seem to want to embrace what was coming, and now they are. It's a big difference in attitude. Another thing that we're going to hear more and more about is access to justice, the access to justice movement. States like Utah, California, Illinois, and Arizona, and others are all working towards trying to make some regulatory changes that can help people get access to legal help. We all know lawyers are important. They do good work, but they're expensive, and lots of people just simply can't afford to get the help. So it's interesting that these things are coming along. And I mentioned Utah, California, Illinois, and Arizona. Utah, just a few months ago, the Supreme Court of Utah approved a new thing called the Utah Sandbox. They gave the okay to this regulatory sandbox, and for the next 2 years, lawyers and non-lawyers are going to be able to experiment with new types of legal businesses that are aimed at reducing the access to justice gap, is what they're calling it. And one of the Utah Supreme Court justices recently said that, hey, we just can't volunteer ourselves across this access to justice gap. We've spent billions of dollars trying to do this, and it doesn't work. And if we keep doing it, that's Einstein's very definition of insanity, right? So what he says is needed, and what they are doing by opening up these sandboxes is to introduce a market-based approach that simultaneously respects and protects consumer needs. So really what that boils down to is non-lawyers are going to be able to create or provide certain legal documents. And so this is really it's a big shift since this article came out that I'm referring to right now. Arizona has also started taking applications into their sandbox. Our company, EP Navigator, feels very fortunate that we've been able to get approved within the Utah sandbox, and that's going to help us do some creative things, and we're very excited about that. I'm happy to answer some questions about that if there are any later. All of this has led to what I call a seismic shift, and I mean that from the standpoint of the attitude of large firms, whether it be broker-dealers or life insurance companies. There's been a complete shift in their willingness to work with and partner with technology-based legal solutions. A few years ago when I started, it was completely taboo, and there's been a very clear shift now. There's firms like Creative Planning is one that I know I've seen television commercials where they flat out say, hey, we not only do taxes and financial planning, we also do estate planning. And that was unheard of just a few years ago. Another indicator was just about a year ago, MetLife purchased a company called Willing, which is just a very basic DIY online will producer. And so definitely a shift here. And I think a lot of it's driven by not just the technology, but the customer themselves is demanding access to these things through their trusted advisor relationships. All that is clearly pushing, and we're seeing more and more DIY solutions. Probably the most well-known is the LegalZoom, Rocket Lawyer. Many of these are good solutions in some cases, but there are some hurdles there too. We need to be careful with the true DIY. One of the things in the DIY space is that they seem to favor pushing the attorney out of the process, where here at EP Navigator, we want to keep the attorney in the process in a key role, but allow technology to assist them in their job. And that makes access to easier, keeps price points more reasonable, but our clients are still able to get super high quality custom documents. So those are some of the major trends we see happening. I threw this next slide in for just a little bit of fun. I think it's interesting that, and I'm by no means an expert in blockchain and cryptocurrencies. It's something I've read a bit about, and we definitely have our eye on. But I think if there's going to be a massive disruption in the estate planning space, blockchain technology is something to keep an eye on. For those of you who are familiar, I think smart contracts pose a really interesting solution to allowing wills or trusts even to go online, and when someone passes away, to start an automatic process of transferring assets and moving assets to wherever that person wanted to be. So I think blockchain is going to be kind of fun to watch. So I just threw this. It's not necessarily a trend at this point, but I think it's going to be a fun thing to watch over the years. So let's talk a little bit more about estate planning and who's really exposed. If you do a simple Google search, depending on what your search provides, you're going to find statistics somewhere in the neighborhood of 60 to 70% of adults don't even have a simple estate plan in place. Around 15 to 20% more don't have a plan that reflects their current wishes. In other words, it's probably been sitting on a shelf somewhere and it needs some updating. And so I wonder, just out of curiosity, about this group. From talking to Roland and seeing who this group is made up of, I'm guessing your percentages are going to be significantly better, but I'd also be willing to bet that there's probably somewhere between 30 and 50% of you who don't have your documents either, or they're not up to date. So why is that? Why is it that there are so many people that don't get this pretty simple job done? Well, that's the friction I've been talking about. And it's a combination of what I really myths and excuses. I mean, human nature is sometimes to procrastinate, except for I've got a few friends that never procrastinate. But, you know, it's real easy to, when there's all this information out there, and you can see here, this was, I think, 18 or 19 things that came to mind that when I was doing this, that, you know, that we hear all the time. And so I thought, well, I'm not going to deal with 19 of them, but let's boil this down to maybe the top 5. And the first one that I hear the most is, you know, people don't, if you ask someone, why don't we get it done? The answer you're going to get is, well, people don't want to think about their mortality. I don't think that's the number one reason people don't get it done personally. I think that's the number one reason people say other people don't want to do it. But I think sometimes it's too complicated. And this number 2 here encompasses a bunch of those other ones that were on the prior slide. I frankly think, you know, it's kind of overwhelming. I think there's a lot of misinformation out there, and just the thought of it just says, people just say, you know what, I'll deal with that later. Number 3, we hear a ton. You know, once I do an estate plan, it's going to require more maintenance, and I'm going to lose control over my assets, and it's going to be expensive to maintain. And that's not true. Most people, once you put your estate plan in place, it's simply a matter of making sure you get it executed and done. And once it's done, you're probably going to put it on a shelf and forget about it and not really deal with it for a while. Obviously, you do need to maintain it, but, you know, we're talking about having a checkup every few years and asking some key questions. But most people, you're not going to have to do much with it moving forward. Certainly the cost. We've talked a bunch about that tonight as we talk about access to affordable legal help and all that. Price is a problem for sure. And I know a good number of you are in California and maybe even around the Bay Area where I grew up. I know for sure that if you're to go down the street to a decent estate planning attorney, you're probably talking $3,000 to $5,000 these days to get that done. And that's going to cause a lot of people to pause and say, you know what, I'd rather go on vacation. So cost is definitely a good excuse. And 5 here, if I have a will, I don't need to worry about probate. I've been hearing this a lot lately, and it's kind of interesting to me. We need to be aware that a will is better than nothing. Many of you probably know that if you die without one, they call it intestate, and the state of California or wherever you live is going to get involved, and they're going to play a key role in who gets your estate. A will is a step better, but all that does is tell the court who should get your assets after the probate proceeding is done. So why do we need an estate plan? What's the hurry, right? Well, number 1, and I think this is huge, is none of us know what tomorrow would bring. If we were on this call a year ago, I don't think anybody anticipated COVID-19. We had no clue what was coming. So we just don't know what's around the corner, whether it's something like COVID or an accident or whatever it might, illness, whatever it might be. Ignoring that isn't very smart. We need it because we need to identify who's going to oversee our finances if we're sick or disabled. We need it because we need to identify who would make medical decisions for us if we're sick or disabled. It doesn't always work that it's automatically a spouse or someone in your family. We want to make sure that our wishes are fulfilled when we do die, that things happen the way we'd like them to happen. It's going to minimize or eliminate the costly and time-consuming probate process. Many of you are in California. California is famous for probably being one of the worst states to be in for a probate. It's generally a year to 2 years that an estate is tied up in probate, and it's quite costly. I'm in another state that's here in Florida that's equally as challenging, if not more. A real key thing about estate planning, and this often thankfully is a hot button for younger people who aren't really necessarily thinking about their demise, but they realize it's important that they establish guardianship for their minor children if something were to happen to them. So that's a really important one. And also equally important, doesn't necessarily always feel like it, but we get a lot of feedback from people that, they're super thankful once they get this in place. And it really does give peace of mind. Once you have your things in order and you go about your life knowing that, God forbid something does happen to you, that your family's not going to be left with a big mess. So the peace of mind is a big item. I thought here we'll explore a few examples of things that might happen that will illustrate why it's important. So here we got Mary and Jason and their little baby Jane, and they're on their way to grandma and they're in a car accident. And unfortunately, Mary and Jason pass in that car accident. What's going to happen there? Well, without an estate plan, very possible that Mary's parents and Jason's parents get in an argument about who ought to take care of baby Jane. So we've got a custody battle. They both lawyer up, and now the feelings are hurt and things get a little bit nasty. All that can be avoided by putting some simple papers together, important legal documents together. We can avoid that. Another example, and this is one that I would love to see more and more people do this. This is why we allow our financial advisors that we work with to provide powers of attorney at no charge, is that young people need these simple documents at minimum. So here we got a kid off to school having a good time, and he and his buddies hit the slopes, and unfortunately John gets off trail and hits a tree. He ends up in a coma. If he doesn't have an estate plan and he's an adult now, his parents don't automatically get to know what his situation is because of HIPAA. And if he hasn't done a plan or put a power of attorney together, he doesn't have anybody able to make healthcare decisions for him. So parents end up in court, lawyering up and petitioning to become John's conservator. All that also avoided if we take the time and do some basic planning. Excuse me. Most common, thankfully, most of us get through life and we get to our later years and move along. But we've got some challenges there too. So Sam's got some aging parents and they get to the point where they're incapable of taking care of things themselves. And without an estate plan, they're going to be in a situation where, again, medical records are sealed. They're petitioning a court for conservatorship. Locating assets can be difficult. Again, we need a lawyer to probate assets. And like I mentioned a little bit ago, probate can be 12 to 18 months and quite a big hassle for the family. And the last little sample here is a couple of business partners. One of them passes away, and without any planning in place, things happen like you end up with a new partner and it's your deceased friend and partner's wife, and she wants to run the business kind of thing. And, both sides end up with lawyers and so forth. So you get the picture. Just to lighten it up here a little bit, I found this the other day. I didn't know this, but probate comes from a Latin verb probare. I thought that was kind of interesting. And it means having been proved. And it makes perfect sense. That's what happens in the court. When you go through the probate process, it's all about proving up ownership, making sure there's clear title. The court has to be involved in that. And then once that's determined, those assets can go off to heirs. Let's talk about how a will compares to a trust a little bit. With a will, as I mentioned earlier on, it doesn't avoid probate. It just tells the court after probate where those assets should go. Probating a will requires attorneys, which aren't free. It requires typically a 1 to 2 year delay in time until distributions are made. It's a public proceeding. I call it maximum emotional impact because at a time when the family is generally grieving and would like to get on with life, instead the executor and the family are going through this court proceeding for an extended period of time. Many times it can involve court-appointed guardians and conservatorships. Obviously, along with the attorney's fees, there's actually court filing fees. So there's expensive court fees involved. You're going to pay the maximum amount of estate taxes. This is not, in today's world, necessarily a big issue, with the federal inheritance tax exemption being what it is at a little over $22 million. The next item is actually a big one. Wills tend to be a lot easier to contest versus trust. And again, it's a court-controlled and public proceeding. For most folks in California, if they own some assets and own some real estate, a living trust is most times the best solution. The trust itself is going to see to it that you go straight to the heirs. You're not going to need an attorney once your estate plan is in place. The court's not going to be involved, so there's no probate. Less likely to have any issues around guardianship issues or conservatorships. You're going to limit, I should say there's no hassle, shouldn't say there's no hassles as I look at that. Settling someone's estate is always a job. I've been involved in a couple of them at this point, but it's going to minimize hassles for sure. You're going to minimize unnecessary expenses, taxes. There is typically a no contest clause in trusts. They are much more bulletproof than a will, and you're going to double you're going to get the dual federal inheritance tax exemption. Again, I understand that that's not going to affect a lot of people at this point with that being so high, but it does sunset, correct me if I'm wrong, in I think 4 years and maybe sooner, who knows. So you may end up like the old days getting a nice dual benefit there. And again, this side is private completely. There's no court involved, and so people can't be snooping around and see what you had and didn't have and who got what. Living probate. So this is what we talked about early on. I got into the Latin thing here. Ante mortem is, before death probate. Obviously, we know probate happens when people die, but this thing that people don't really talk a lot about, and I'm big on, is that living probate can occur when you're alive, and it happens when you become incapacitated and you're no longer able to manage your own affairs. When this happens, it's an important process that we assign someone to take care of us in those cases. So it's a necessary process, but if you haven't taken the right steps, it's going to be costly because again, you're having to go to court. So if I become if I'm on my way to Cabo tomorrow morning, if I get injured somehow and I become incapacitated and I don't have my correct documents in place, my family is going to be going to court, and it might end up being two of my brothers fighting over who's going to be my conservator because they both like me. So, or I think they do. Anyway, so it can be costly. And at a time when, it's a very difficult time, courts aren't famous for moving fast. It's typically not the fastest process in the world. Obviously, it's bureaucratic being a court deal. Again, anything in the courts is, most things are going to be public. And most importantly, unfortunately, many times when the family goes to court and ends up petitioning for conservatorship, they're dueling family members, and who knows what the outcome will be. And it's not always going to be the outcome that you would have liked. So how do we avoid this? The first thing you need to do is you've got to get your will or your trust in place. And name someone to be your executor. Create a power of attorney for financial decisions. Do that ahead of time. Along with that, you're going to want to create a power of attorney for your healthcare decisions. In addition to your healthcare surrogate, you're going to want to name or fill out what we call your advanced health care directive or your living will. And that's going to get more specific about end of life decisions and so forth, and whether you want to be on life support and all that. It's all pretty heavy duty stuff, but it can be handled very quickly and easily in our process. And obviously having these things done ahead of time is going to eliminate this living probate idea. So EP Navigator, really, as I mentioned, we've set out to really change the landscape. In our technology, you're going to have the ability to create, execute, and fund an estate plan that's specific to your needs. You'll be able to maintain it on our platform. We've been around. Our software has been around for 4 years. Our company's been around for 30. We know when you need to make changes. We can help you make those changes. They're easily made within our platform. Within our platform, you can share. Not only are you going to be able to store your documents, you'll be able to share them with your family if you'd like. And we even have the ability to help settling the estate when that time comes. With our software and with our cloud-based platform, our system is not like a DIY system where you would be necessarily tasked with trying to figure out what documents you ought to have. Our system is going to allow the attorneys to assist you with that process to decide whether you need a last will and testament and what powers of attorney should look like. Do you need a living trust? And obviously you need your healthcare directives that we just talked about. So what we've done here is we've really embraced technology. We're scratching the surface of AI. We're not technically AI, but we've got a system in place that allows our attorneys to practice law via our technology. What I mean by that is our attorneys can, they manage the software, they manage the online interview that the customer goes through, and they can build in certain guidelines into that technology, which means that those algorithms that are built into our tech allow the attorney to have automated decisions. A good example for this is obviously interest rates are crazy low. If I'm probably talking to a bunch of homeowners, and I'm guessing many of you within the last year or two have refinanced your home. When you call the bank these days to refinance your home, they're going to look at your credit score. You're going to answer a few questions. They're going to look at your income. And if your answers stay within the bank's guidelines, they're going to automatically approve your loan, right? If your answers, for whatever reason, get a little bit outside the bank's guidelines, they're going to say, hey, wait a second, tell me more, or they're going to decline that loan. We've done the same thing in estate planning. We got 30 years of experience that tell us, hey, if we ask all these questions and the client answers in a certain way and stay within the attorney managed guidelines, we can automatically approve documents to be created. So our algorithms assist the attorney in that process so that we can not only approve them, we can recommend the right documents on the front end. Taking it to the next step, the software and our system allow us to then create customized documents based on your answers. So if you need to do certain things within your for your situation, hold assets in trust for minor children, or you have a special needs child, or whatever it is, we'll build customized documents as you move through the process, and our tech allows them to do that. This is really awesome. Part of what we do is the guidelines I mentioned is if the client's answers get outside of our guidelines, our tech is going to flag that file and it's not going to get approved. That automatically, it means then that we're going to put that person in contact with the lawyer so that we make sure we're doing the right thing for each case. So we're going to identify that more complex situation and then get you the right help. And last, those fully executed documents then are stored securely on the cloud, within your own vault or dashboard, and from there you'll be able to manage your documents. So just kind of in summary, we've really streamlined the process. Roland talked about the human element in my introduction. That's a very important part of our process. We have no desire to completely eliminate the human in this. It's a very important part. So we say we're technology paired with humans. We have the ability to do estate planning in 49 states. As I mentioned, our attorneys are practicing law via our software. I wanted to say that again because different than a LegalZoom or Rocket Lawyer or many of the other DIY platforms, all of our documents come from the lawyer or a lawyer in your state. So the very first thing when we send a set of physical documents out to a customer, and by the way, we do both physical documents as well as digital documents. When we send those physical documents out, the very first thing on the when you open up that binder is a letter from the attorney who's responsible for creating those documents with their contact information and so forth. That's a big deal. We've got a lawyer responsible for our documents, not just a DIY template. As I mentioned too, the attorneys are, the software will identify the more complex cases and put you in contact or the customer in contact with the lawyer's office to sort that out and make sure we do the right thing for you. Another item I wanted to mention here was that once your documents are on or in our system, we'll help you maintain them as time goes by and you need to make amendments. It's very simple to do that by logging into your dashboard and simply requesting an amendment. Let the system know what it is you want to change. The attorney via the software re-interviews you and will then create the amendment for you. And again, all that's going to be stored on the cloud. So that kind of wraps it up for me. To learn more about how to get started with your custom estate plan, you can go to the link here that's listed. And we've got a special offer there for everybody who's attending tonight. If you're interested, you can reach out to us and we're happy to answer questions. And I think Roland's probably got a few questions for me to answer now, and I've got time to do it. So let's do it.
Awesome. Thanks, Chris.
Yeah.
So there's a question that came in from GM, and he or she is asking, what's the name of the software that you have been using for this 4 years? So maybe just talk about what you mean by the 4 years, and then but the company is 30 years, and just
sure.
Kinda, yep.
Sure. So our company was started originally as Legacy Legal out of San Diego, California, by a father and son financial advisor team. In 1990, they were a little bit frustrated about access to good estate planning that didn't break the bank. And so they started Legacy Legal way back then. When I was a financial advisor, I used that service for almost 10 years, did over 200 estate plans for my own clients at the time. And then fast forward to a few years ago, the son of the father-son team decided to take advantage of technology and build this new platform. And so he built out that platform, or he called me and asked if I wanted to partner. And together, we've built this platform out and we launched it just about 4 years ago. That answer the question?
Yeah, and then I think the name is called Estate Plan Navigator. Or otherwise EP Navigator is the name of the software.
That's correct, and that's the financial services version, or the brand that we promote to the financial services sector is the EP Navigator.
Okay, so someone is asking, Dick is asking that living trust typically costs around $3,000 to $5,000. Is this method less costly?
Significantly, and yes, because we're allowing the software to do a lot of the lifting for the attorney, you're paying a fraction of what that would normally cost, and that pricing is available. The special offer pricing is available at the link there on the screen.
Well, and I would also add that there's also some benefits to it. Yeah, I think the traditional way of the $3,000 to $5,000 normally you get a binder, and then the binder is probably stuck in some closet. So then when there's an event, and people are just trying to go through the deceased's house to look for that binder, by having it on the cloud, you have some of the advantages of the cloud. So it's both, you'll get a physical binder as well, right? Chris, correct me if I'm wrong, but then also there's an online access where you can actually give role-based access control to your trustees, your successor trustees, to your powers of attorney, so that they can only see what they should be seeing, and you control that as the original trustee or as the original grantor. And then the other aspect that is super beneficial is normally an estate plan that's provided by an attorney of $3,000 to $5,000. Well, if you go and see them 10 years later because the state laws has drastically changed, well, they'll either say, you know what, this is too old, let's start all over, so pay me another $3,000 to $5,000, or they'll say, well, I'll just bill you hourly, right? Which probably ends up being probably in that ballpark of $3,000 to $5,000, right? So what is that for EP?
Yeah, that's a great question, because we do two things. On our platform, amendments to your revocable trust cost $150. So it's extremely reasonable. And to your point about, when your estate plan gets a little older, it's important to note that if you have if someone out there is listening today and they've got an existing estate plan, a revocable trust or will or whatever, our platform will handle that. We do lots and lots of cases where folks come in and say, hey, I did my trust years ago, but I can't find the lawyer, or, he moved out of state or whatever it is. It's far more cost effective to come to us and let us build your new plan and just encapsulate your old wishes along with your new. And we can do that on the platform. So we do probably 15-20% of our businesses replacing older documents.
Okay, any other questions at this point for Chris? Do California courts recognize electronic estate plans? And I think it might be worthwhile to clarify before even that question, Chris, is this like a separate estate plan? Is this like an electronic estate plan that's different than a, quote unquote, normal estate plan?
Yeah, no, good. Yeah, no, these are normal, we'll call them normal estate plans, with the difference of the technology that's aiding it, the fact that it's stored in the cloud, et cetera. So as far as electronic documents, I think we're still in the world of needing these so-called normal documents. I know certain states, especially with COVID, have started to expand the rules around, can I e-sign my estate planning documents? I don't remember the list. There's a handful of states that do allow e-signatures and e-notarizations of their documents, but I would have to double check in California if they're on that list at this point. We do not do any e-signatures. We, at this point, are staying traditional and sticking with wet signatures on all of our documents.
Right. So yeah, this is not there's not an electronic version of the, it's electronic in that you have access to, what the plan actually entails on the cloud and electronically, but it's not a brand new experiment in just this purely electronic estate plan. That's not what's happening here.
That's correct.
Yeah.
Yep.
And then next question is, do you maintain a list of attorneys and locations that use the software? So you said that there were 49 states. Are there, I guess what's the one state that's missing? Is it Hawaii or Alaska?
Good guesses, but it's Louisiana.
Oh, okay.
Louisiana still practices a sort of this hybrid that includes Napoleonic law. And so it wreaks havoc with a scalable solution like ours. So we're figuring it out. We will get there sometime next year and add Louisiana, I believe. One of our two managing attorneys is actually an LSU grad. But so we'll get Louisiana, but that's the one that's not included right now. And yes, we do keep a list of attorneys. We typically have 2 attorneys in each state. Our solution is built around allowing the software to do a lot of the work. And so if the person who's asking that is wanting to know if that attorney is geographically close to them for some assistance at some point, we can certainly find that out for them. But we've found, in doing 100,000 plans, it's really not necessary. With today's technology, it's not necessary unless that's what the client wants. If you're the type of person that has to be eyeball to eyeball with a lawyer, we respect that, but we would also respectfully send you directly to the lawyer to do that, and this wouldn't be the solution for you. Some people, that's the case, and that's fine.
So let's see, this just a couple of questions about the cost and how long the offer is available. So the offer is available on the website that Chris had pointed out. So let me just type that in. And then, it explains what the offer is. And then as far as how long it's available, I don't know. I guess maybe until the end of the year. Chris, what?
Happy to continue it till the end of the year. That's fine.
Yeah.
Yep. Don't
Okay.
Change.
And then another question that came in from John. How do I find an attorney? Well, so within the software, it allows you to pick, and as Chris had mentioned, there's a couple of attorneys, right? And usually you could pick one or the other. And then in theory, I guess if your question is how do you find an attorney outside of the software, you could probably go to Google for that.
Yeah, within our system, if you start down the road using one of the options that we're providing there, like Roland said, you'll choose from a drop-down menu. If you're in California, I believe there's going to be 3 choices. We're more than happy to provide you some information on those lawyers, but we do vet those lawyers out. Every single one of them is interviewed by our managing team. They have to be a member of the bar in that state. They have to be in good standing. Typically, we're going to require that they be somewhere a minimum of 20% of their practice needs to be focused in estate planning. And then we're going to grill them a little bit on, some of the ins and outs, some of the more complex work that might be coming their way. So we do vet them out. And in California, we've got some great long-time estate planning attorneys that I think anybody would be happy to work with. Unless you have some really exotic, complex scenarios. But we have a great group of attorneys in California.
You know what? I think I understand John's question now. He's saying how, the process. I think John, you're thinking that to get this process started, you have to find the attorney. No, that's not actually how it works. So if you go to that link that was just posted, what you would do is, sign up for one of those, 2 options. And then when you sign up, then you access the software, right? You don't, I don't think, payments taken when you, click one or the other. You just fill out your information. And then what happens is then you'd either work directly with EP Cloud or EP Navigator, or you work with a local advisor, and then they would set you up, and then during the registration process, then the attorney would be matched to your file. You don't find an attorney to get the process started.
Yeah, and you made a good point, Roland, too, is that we don't collect any money in the process until the attorney's made a recommendation for what documents the customer needs and approved those documents, provided a summary of what it is they're building for their estate plan, and given them an opportunity to view a complete draft set of documents. It's not until the customer has seen all that that we would ever charge money. We don't charge it on the front end. So we want you to be comfortable and happy moving through the process. Get your approval from the lawyer. Make sure there's nothing complex going on. View your plan, and then we collect payment.
Okay, we have another question here from Jeff, and he said, great presentation. As the state laws change, how does the cloud software stay up to date, and what is the recommended way to review and update the plan?
Yeah, really, really good question. I mentioned in the presentation that typically people put their plans together and put them on a shelf and forget about them. And there's nothing wrong with that for the most part. State planning law, it moves at a snail's pace. Things don't change very often. What does happen is occasionally estate planning attorneys discover some new language that they think is cool and may help in certain scenarios. The other thing happened in this year, Roland, you're probably well aware of the Secure Act that came about in January, which changed the rules around qualified money and your ability to do the stretch IRA type strategies.
Mm-hmm.
When those types of things happen, we're on top of them. We check the language within our documents. We make sure it's up to speed. We have an audit process whereby we audit every single state every year. For not only are we in line with current statutes, but is there any of that new language I mentioned that might be helpful that we could add to our documents? So we stay on top of it, and if something changes, we notify everybody.
Let's see. Okay, what are the various components of the estate plan, e.g. Ergo or trust, will, advanced health directives, etc.?
Yeah. So I can run down the big list. We'll start with a will package. If the attorney says, "Hey, look, you don't have a lot right at this point. You just need a basic will package," then that will package is going to include the will itself. It's going to include a power of attorney for healthcare, power of attorney for financial decisions, the advanced healthcare directive, of course. And then we also include in that package of physical documents, we include, some organizational things about, what to do when someone dies, information for your surviving family, personal letter of direction, which is helpful. So that all comes with the will package. On the trust side, the revocable trust side, what's included in that package is the revocable trust itself, what's called a certification of trust, which is sort of like the ID card for the trust. It's a short version. The certification of trust, the pour over wills, powers of attorney, a thing called a comprehensive transfer document. It's similar to the pour over will to try and catch documents that you might have forgot to put into your trust. We've got information for survivors, what to do when someone dies, intent to return home form for Medicaid planning. There's all kinds. Our 30 years of experience have really taught us, and we've built a very comprehensive set of documents. Everything's there in that package, with the exception of if you're going to be transferring your real estate into your trust, you're going to need a deed to transfer the real property into the name of your trust. We have a service where you can do that as well. We charge $150 per deed to do those transfers. But everything's there. It's a very comprehensive package. Sorry for the long-winded answer, but I think that covered everything.
Someone is asking if there's a trial or a demo of the software before paying.
Is this an end user, someone who's wanting to create documents?
Yes,
or, yeah,
that's right.
No, no, but we'd be happy to, send out a sample set of documents to someone if they want to contact us through the link that's provided there. Let us know, and I'm happy to share a sample of what it is they've received.
Yeah, I think John, who asked that question, like you said, Chris, money isn't charged until the lawyer certifies the documents, right? And then they have a chance to review those documents. Okay.
Yeah, and more importantly, we give them, once they have received their documents, they have 30 days to make any adjustments that they want for no charge, and 30-day money back guarantee, no questions asked. For some reason they're not happy with their documents, we're going to give them their money back.
Got it. Okay. And then a question is, what if you straddle two states, like for instance, California and Nevada? Does it matter in which state you submit your estate plan?
No, you're just gonna put in your state of legal residence. There's two things that are important. What's your state of legal residence, which we're going to ask you in the software, and then it separately is what state are you going to sign them in, which it really just goes to providing the correct signing documents and notarization information. But yeah.
Right. Yeah, because I think the laws that dictate or that apply to trust law, it's a federal. Those are at the federal level, right?
That's correct.
Yeah. Okay. So Mary is asking, with Prop 19 recently passing in California, will that require the estate plan?
You're going to have to tell me about Prop 19 in California, because
so Prop 19, it pertains to some of the modifications around the tax implications of property transfers.
Oh, okay.
Yeah. So go ahead.
Yeah, I was going to say, I can't answer that with 100% certainty, but I can with 99.9 is that it will not. I don't think it would affect. Maybe I'm not hearing the question right, but as far as transferring ownership from yourself to yourself as the trustee of your trust, it historically has never been a taxable event. Every county has what they call a preliminary change of ownership report. It gets sent in with the deed that just tells the county you're simply transferring ownership to a trust, and it's not a taxable event. So I'd be shocked if that changed.
Yeah, I think I can chime in a little bit on that, Mary. Mary, this is talking about, so the structure of the trust is to avoid probate. Prop 19 pertains to property tax reassessments upon transfers, right? So that's that's the difference. It's there's still going to be whatever tax implications are going to be, there's still going to be tax assessed if California changes the law through this proposition for certain rental properties, and it's going to be reassessed at the the new property tax, the higher property tax rate.
Yeah, by moving the property to a trust. Sorry to interrupt you, Roland. I think I'm catching myself up here. I'm with you. By moving to a trust, it's not going to change the reassessment situation, right?
Well, no, Prop 19 says that if the inherited homes are not used as a principal residence, right, such as secondary homes or rental, they will be reassessed at market value when transferred.
Right.
Right.
Okay.
But then that's sort of that's a tax issue. But what we're talking about here with the trust, the estate planning, is to avoid the probate.
Absolutely. That's what this is all about. Avoiding probate.
So whether it's in the living trust or not, or whether you have the estate plan or not, California is going to collect those taxes, or do that reassessment on the property tax irregardless, right? We're talking about avoiding probate. So, okay. So, has any of the trust that's been created with your software been contested in court and lost?
Great question. No. In fact, that we, in 30 years prior, and so if I take the 30 years, there's been 6 cases that I'm aware of that where a court got involved on some level. Our trusts have never been penetrated. So we have a great track record.
Yeah, just generally speaking, I mean, because it's all a private affair, and you know, these trusts, you know that a lot of the wealthy and even members of Congress, they use the trust law to their advantage. It's
absolutely
it's very different in that, you know, when you contest a will, you know. So if I set up a living trust, do I have to rename all my financial accounts to the name of the trust?
You don't have to do anything. You'll probably work with your financial advisor a little bit on that to make some decisions, but typically anything that is a probatable asset, such as real estate or certain financial accounts, IRAs and 401ks and life insurance are non-probatable, so you wouldn't do those. But you're going to want to at least explore re-registering those probatable assets, and the process these days is actually quite easy to do. And one of the things I mentioned earlier about the myths and excuses people use is, you know, they kind of fear that process of re-registering their assets, or that they think sometimes, for instance, I hear a lot that if I put my house in my trust, I won't be able to refinance it again. You know, I hear things like that. It's just, that's not true. It's actually a really easy process. Banks are used to doing it all the time. And anything you want to avoid probate with, you'll want to transfer to the trust. And many times, you know, Roland, you know this, we can set up TOD, or transfer on death accounts, with the brokers or the banks, right?
Mm-hmm.
But and that's fine. But maybe the folks want to hold assets in trust for their kids till they get a little older, or maybe dole it out over time, right? And so you can't do that with a simple TOD account. So if you've got some ideas about how you might want to be creative and we call it, have some control from the grave, then trusts are great for that. So anyway, I went off a little sideways there, but hope that answered the question.
And then the last question here, do the documents cover right to occupy versus life estate if necessary?
Wow, that's a great. I'm glad I got that question. It's the one I use in a lot of my presentations, is the life estate, and it's the first one I saw. What really showed me that what our software is capable of doing sometimes. And I don't want to build this up that our software does everything, because there are certainly cases where our software is not the solution. But for most people, it's a great solution. And the life estate is one of those things that happens. Yeah, if somebody's got a piece of property that they're holding separately, but for instance, it's a second marriage, and let's say the woman has never put her new spouse on title to that home, but if she died, she would like her spouse to be able to stay there. Our software will do that. We'll put a life estate in automatically. The software does it, and there's no additional charge for it.
Excellent. Great. And yeah, somebody's just said, great presentation. Many thanks, and God bless to all. So with that, we'll just end it there. Thanks for your time, Chris, and appreciate. One last question was, somebody was wondering if they can get a copy of the presentation.
Are you going to circulate it, Roland? I know you mentioned that you might be.
Well, sure. You know, go ahead and so on the link that was provided, there's you know, if you want some additional information, somebody's asking for your email. You know, just ask for it on the on that link, and then we'll get you, you know, whatever folks need. So
great.
All right, great.
Perfect.
Have a great evening.